Next up, we have a discussion on race and capital punishment. Moderating the panel is Alex Klein, and our panelists are Daniel Harawa, John Bessler, and Robert Tsai. John Bessler teaches at the University of Baltimore School of Law and the Georgetown University Law Center. He has authored multiple books on capital punishment, including The Death Penalty as Torture, From the Dark Ages to Abolition, Cruel and Unusual, The American Death Penalty and the Founders' Eighth Amendment, and Legacy of Violence, Lynch Mobs and the Execution in Minnesota. He served as an editor in Justice Stephen Breyer's Against the Death Penalty and his book, The Birth of the American Law, An Italian Philosopher and the American Revolution, won the Scribes Book Award for the best work of legal scholarship published during the previous year. He has also taught at the University of Minnesota, the George Washington University, Rutgers, the University of Aberdeen in Scotland, and in 2018, he received the University System of Maryland Board of Regents Faculty Award for his scholarship. Daniel Harawa is an associate professor of law at Washington University in St. Louis, where he directs the appellate clinic. Daniel's research interests focus on the intersection of race, civil rights, and criminal law, and whether adequate process is afforded to criminal defendants. Daniel also litigates civil rights and criminal cases before the Supreme Court and the Federal Court of Appeals across the country. Prior to joining the WashU faculty, Daniel was the assistant counsel at the NAACP Legal Defense Fund and an appellate staff attorney at the Public Defender Service for the District of Columbia. Daniel is a graduate of the University of Richmond and Georgetown University Law Center. Following law school, Daniel clerked for, in my opinion, the dopest federal judge in the nation, the Honorable Roger L. Gregory of the United States Court of Appeals for the Fourth Circuit. Robert Tsai is a professor of law and alumni law scholar at Boston University School of Law. Tsai is a graduate of Yale Law School and clerk for Denny Chin and Hugh Browns. He's the author of 3 books on constitutional theory and legal history, including his latest, Practical Equality, Forging Justice in a Divided Nation. His current book project, Ask the Impossible, explores the legal strategies and organizing tactics of anti-death penalty activists in the Deep South during the 1980s and 1990s. The early decades of mass incarceration in the United States. Based on archival research and the interviews with staff members of the Southern Center for Human Rights, the book shows what can be accomplished to resist a rising tide of tough on crime policies that fell hardest on the poor and racial minorities. Last but not least, we have Professor Alexandra Klein. She researches and teaches in the area of criminal law, criminal procedure, and constitutional law, and the death penalty. Her scholarship has been published in or is forthcoming in the Ohio State Law Review, the Florida Law Review, and the Washington and Lee Law Review. Before joining Washington and Lee University School of Law, Klein served as a judicial clerk to the Honorable Sally D. Atkins of the Maryland Court of Appeals and the Honorable Danny J. Boggs of the United States Court of Appeals for the Sixth Circuit. Klein received her JD summa cum laude from the Washington and Lee University School of Law. She served as a senior articles editor in the Washington and Lee Law Review and received the Washington and Lee Law Council Law Review Award, the Clinical Legal Education Association Award, the Barry W. Sullivan Constitutional Law Award, and the John W. Davis Prize for Law. Professor Klein graduated Order of the Coif and was inducted into Phi Delta Phi and Omicron Delta Kappa. Klein served in the United States Peace Corps and the Republic of Moldova from 2008 to 2010, received her BFA cum laude for the Virginia Commonwealth University, and she is admitted to the bar of the Commonwealth of Virginia. With that being said, I'll turn things over to Professor Klein.
Thanks so much, Chris. I'll keep this brief before we turn it over to our panelists. The topic of this panel is race and capital punishment. And capital punishment in the United States really can't be disentangled from this country's history of racial discrimination and oppression. The death penalty was certainly a tool of control, oppression, and terrorization of both free and enslaved Black people. And Virginia has executed far more Black people than white people for homicide and non-homicide crimes throughout its history. When Virginia abolished the death penalty last year, legislators who supported the bill emphasized its importance as an act of racial justice. Some of the supporters linked it directly to lynching, discussing the well-known and analyzed relationship between lynching and capital punishment. And when the bill was signed, the governor's remarks, as well as the remarks of the attendees, acknowledged Virginia's disturbing history with race and capital punishment as a reason to abolish the use of the death penalty. I'm going to go ahead and turn it over to our excellent speakers, and please put your any questions into the Q&A. Each of the speakers will present, and then we'll have time for questions. So we'll start with Professor Tsai.
Thanks. It's a pleasure to be with everybody. Alex, before I get started, just to verify, how much time should we go for each speaker?
I believe it was 15 minutes.
Okay, great. Thanks. I assume you'll start waving at me if I approach that. Thanks so much. I want to begin just by making a brief apology. It's great to be with everybody, to see all of you, and I look forward to hearing each panelist's presentation. I will have to cut out just a little bit early, unfortunately, so I may miss out on part of the discussion section. I've got to run off and teach a election law class about 2:15. But it is my pleasure to be with you for this period of time and to talk to you a little bit about a project that I've been working on for the last few years, and to focus in on a part of the book project that highlights what a number of anti-death penalty lawyers and activists based at the Southern Center for Human Rights, but also working with the NAACP, the ACLU, who had a presence as well down in Atlanta and the Deep South, sort of how they reacted to, resisted, and in some ways subverted the Supreme Court's ruling in McCloskey versus Kemp. So, you know, before sort of getting into that, I think just briefly, since I'm not sure you guys have talked about McCloskey so far at this conference, but just so that, you know, everybody in attendance has some sense of where McCloskey versus Kemp kind of comes into the picture. You know, McCloskey versus Kemp is this 5-4 decision that gets handed down in what, 87 or so. And it comes in a particularly important moment of time. Certainly, you know, after Furman was handed down, in which the court had expressed some concern, a lot of concern, about arbitrary, irrational procedures used to identify who will get the ultimate punishment. But even when in Gregg versus Georgia, the court sort of permits states to restart the death machines across the country, still says, at least, you know, in theory, that courts care about procedure, process, fairness, and in theory, equality as well. So when McCloskey comes down in 87, right, between Gregg and McCloskey, you have activists on the ground sponsoring litigation to still to test these ideas, right? The court's willingness to enforce notions of fairness and equality. And certainly what we know about you know, the Baldus case is that the NAACP is particularly interested in moving in a quantitative direction, and they go and they get Baldus, who's at the University of Iowa, to do the most sophisticated study at that point of some 2,000 cases in Georgia, from from sort of the moment that Gregg comes down into the 80s, and you know, even Baldus himself says that he's skeptical that he'll find anything that could be useful enough, but he surprises himself with the stark racial disparities that he finds. And I don't want to get too bogged down in disparities because there's a lot of ways to cut the numbers, but I think most people who have looked at the Baldus decision and thought about it agree that the disparities are strongest when it comes to cross-racial killings, right? That the disparities, in other words, the enthusiasm with which prosecutors in Georgia go for the death penalty is most powerful, most consistent when you have a Black defendant and a white victim. I guess one theory is that the desire to vindicate white lives is most powerfully felt in the cross-racial killing context of that sort. They're not as enthusiastic. They were not as enthusiastic when the roles were reversed. We also saw strong disparities if you just try to isolate the prosecutorial discretion, right? That in general, they were. It looked like if there was one actor in the system that either had too much power or in a way that was unconstrained by notions of fairness, or were exercising them in a consistently discriminatory fashion. It was the charging decision, and also when prosecutors took the death penalty then back off the table, right? In what kind of cases were they willing to deal, and which cases were they not willing to deal? So that's kind of what the Baldus studies showed in a very capsule description. But when this gets litigated, as we know, the Supreme Court by 5-4 decision rejects McCloskey's equal protection challenge on the basis of this study. And a lot of treatments there's been a lot of treatments of McCloskey kind of stop at the moment where people feel very demoralized. There are a lot of people who are demoralized. Criminal defense lawyers are demoralized. Anti-death penalty activists are demoralized. Anthony Amsterdam is quoted as calling McCloskey the Dred Scott decision of our time. When I interviewed Brian Stevenson for my book, he talks about being devastated and heartbroken. The feeling that the promise of equality is so disrespected in that decision comes across. Steve Bright, who I also interviewed for this book many times, points back to this decision as a huge turning point in how that organization approached these kinds of cases. But in most treatments, that's kind of where it ends, right? You get a sort of terrible feeling about how terrible the case is, and then we move on as if there's nothing to be done about it. What my project suggests is that for at least a small subset of anti-death penalty activists, and so one question that I haven't answered is how broadly some of these tactics were actually used, but certainly Steve and Brian and others who were working on their cases and in communication with them, and then perhaps to some degree learned about these tactics later, did something different. What I describe after McCloskey is a shift in tactics. I call it doubling down on equality. So the first thing they decided to do is to counteract this sense of despondency. Instead of giving up on our claims of racial equality, which we're often told most people did, they doubled down on equality. But in order to do so, they had to change how they were litigating these claims. They obviously couldn't litigate them in every case. And so they had to look for those kinds of cases in which they could plausibly still bring these kinds of claims. Excuse me. I think that the other thing that they did was to engage in what we might call doctrinal subversion. And so when I interviewed folks, what they often talked about was trying to turn McCloskey from a shield erected by the Supreme Court into a sword. So they were actually running into court in some cases, filing what they themselves called McCloskey motions and demanding McCloskey style hearings in criminal cases. When a typical trial judge would say, "Oh no, let me read that case," and say, "No, this tells me that you can't bring these kinds of claims," they would say, "No, Your Honor. The bottom line is that in McCloskey, the Supreme Court still vindicates, at least in the abstract, the notion of equality and of fairness. And we say that this says that we have a chance to show you that there are certain procedures that are either not fair, that are discriminatory, or that there are players within this county, whether it's the prosecutor, whether it was the way in which jury selection procedures were created and implemented, or whether it's you yourself as judge over this case, exhibit bias, we have a chance to show that that's the case and build a record for it." And so that's what they did in a number of cases. They doubled down on equality. They tried to subvert I think the motivations clearly of Justice Powell, at least, who authored it, because when you go behind the scenes of McCloskey, what we see is he gets very freaked out about the possibility that if McCloskey wins his equality claim, that it's going to bring down the entire criminal justice system. It comes across very clearly as well, right, in the opinion itself. He sees no way of not falling down the slippery slope, and so that means that McCloskey has to lose. We know that the McCloskey decision, Powell tries to insulate the entire criminal justice proceeding and make it harder to bring these kinds of claims. He says that you have to show that in one's individual case that somebody acted in a discriminatory fashion out of bias. And that's the language that gets seized upon by Steve Bright, by Brian Stevenson, by others who are engaged in these new tactics. And they try to show that specific prosecutor or the entire prosecutor's office has a history of discriminating against either Black defendants or in murder cases, trying to manufacture all white juries. They try to bounce judges that they believe have reason to be biased against their clients. And then they, as I sort of alluded to, they try to attack the jury selection proceedings or processes in the first place. And so they do all of these things at the same time, and they sort of ramp up. So one of the things we see is the motions filing, it becomes like, they file like, 5, 10, 15 motions. And they demand hearings on all of these motions. And this, of course, buys time for the client, but it also gives them multiple opportunities to try to build a record of discrimination. At first, we see that the tactics aren't paying off directly. Judges aren't willing to step off their cases. In one case in particular, a judge refuses to step off and gets so upset at being called biased that he himself retains a lawyer of his own and tries to then intervene in the hearing held on the motion. This gets litigated all the way up to the Georgia Supreme Court. And because of the trial judge's involvement, that ultimately ends up getting him bumped off the case. So indirectly, it pays off, the strategy pays off in getting the judge off the case. The Georgia Supreme Court says essentially that the extraordinary lengths to which the trial judge went to protect his own public reputation created the impression, right, of bias in this case. After that case, after the organization showed that it would at times go after judges who might be biased, there were subsequent cases in which the moment they filed the motion to recuse a judge, the judge stepped off the case. And sometimes they were able to cycle through a number of judges. But the true, I think, moment of success, the real big moment of success comes in a case called Horton versus vzant, in which they have an African-American client. They get involved late in the proceeding, that is say at the habeas stage initially. And so they've got to battle against all of the procedural obstacles that one does if one gets in at that stage of the game. But as they're buying time for their client, they also try to find evidence. They come up with their own evidence of how many times the particular prosecutor in that case, tried that case, how many death cases he had done, what was the racial composition of the juries in which he tried all those death cases, how many times he used peremptory strikes, etc. And they were able to then cross-reference all this information with other information in the county, it's pretty extraordinary. They got a hearing on it, even though they lost in front of a federal district judge. The 11th Circuit decision in Horton versus vzant, for the first time, I think, ratifies this innovative strategy of resisting McCloskey versus Kemp. And the evidence that they gather show that the prosecutor in that case had a long history of manufacturing all white juries in death cases, particularly when an African-American defendant was being charged. And the 11th Circuit found that to be a violation, notwithstanding McCloskey versus Kemp. I see I've got a couple minutes. That's the most dramatic example of this strategy working. With that victory in hand, then you can imagine what a lawyer activist can do, right? Once a case has been found to have been tainted because of the behavior of prosecutor, well, in theory, there may have been other cases in which that same prosecutor did similar things. And so suddenly you had justification to go back and at least try to reopen some of those other cases in which either that prosecutor or his colleagues may have engaged in similar tactics to manufacture all white juries. That case then ended up having some legs for quite some time. So I could go on, but I won't. That's one example of why I describe as some of the innovative strategies that we started to see post 87 throughout the 90s. We see this, and eventually these kinds of things begin to pay off, and as I argue, chip away at some of the problems laid down by McCloskey versus Kemp. So thank you so much.
Thank you so much, Professor Tsai. I'm sure there will be questions looking for more details about the topics you've discussed and sort of how these practices worked. I will next turn it over to Professor Bessler.
Great, thank you very much. And thanks, Professor, for that great introduction to this topic. I think it was really terrific. And thanks to the law school for sponsoring this. I wanted to begin by going back just a little bit before McCloskey, of course, and that was a decision in the 80s, and go back to Furman versus Georgia, which of course is the case where the US Supreme Court, in a very short per curiam opinion, I think it was 6 sentences long, said the death penalty violates the 8th and 14th amendments. And Justice Marshall in that case, in his concurrence, said that he believed that some facts would convince even the most hesitant of citizens to condemn the death penalty as a sanction. One of those was how it's discriminatorily applied. That was first and foremost on his list. And then there was also evidence that innocent people had been executed. And Sister Prejean, in her opening comments, really focused on that. And we see the statistics, right, that for every 8 executions, we have 1 exoneration. And so that's a really important point to make in this whole discussion. I think it's really helped to change the public view of the death penalty. But he also talked about how the death penalty itself wreaks havoc on our entire criminal justice system, which I think really, if we think of the death penalty as kind of the tip of the iceberg for how the criminal justice system has been overly vindictive over the years, we see that is a symbol really of that vindictiveness, the death penalty. After the Supreme Court brought back the death penalty in Gregg versus Georgia, we had a number of states reenact death penalty laws in the wake of Furman. Marshall continued speaking out against the death penalty, famously with Justice Brennan dissenting relentlessly in death penalty cases. Marshall, for example, at a speech to the ABA in 1990, said, we cannot let this continue, and talked about how if Gregg had promised that the death penalty was going to be administered in a fair way, the way in which the death penalty was actually administered was he called it a cruel and empty mockery. And I think that's really telling. And I think if you look back at Furman, which is sort of where a lot of people date the modern death penalty, the beginning of that in 1972, you look to see at what the justices who wrote concurrences said in that case about the death penalty. Justice Stewart talked about it as being struck by lightning in terms of who would get the death penalty. Justice Douglas talked about the death penalty being pregnant with discrimination. Justice Marshall focused actually on the data and looked at the data, the raw data, which showed that the death penalty had been administered in a incredibly racially discriminatory fashion. And if we look at the work of the Professor Tsai mentioned Brian Stevenson, whose Equal Justice Initiative had done a report recently about what were called racial terror lynchings. And he identified, I think, more than 4,000 of those lynchings that took place, I think, between, if I remember right, 1877 and 1950, that really terrorized whole communities. And so, and there's racial disparities in terms of who was lynched, actually, and for what kinds of conduct. So we see discrimination in all facets of life, and the death penalty is really rife with discrimination. And I think you really, in some ways, can't separate the death penalty from racial discrimination. I think it was Carroll and Jordan Steiker who actually said that the original sin of the death penalty was the discrimination that was imbued in the death penalty itself. And if we go back to colonial times, we see that oftentimes the death penalty was used to suppress people that were enslaved, people that were trying to get their freedom. There was actually a case in Virginia in 1800, Gabriel's Rebellion. And this leads to actually some correspondence between then Governor Monroe, who was in Richmond. The plan was actually, Gabriel was to take over the capital and to free all the enslaved people in the state. He made a flag, Death or Liberty, I think, is an homage to Patrick Henry and the principles of the American Revolution, which of course there was that promise of equality in the Declaration of Independence that Gabriel and people like Benjamin Banneker actually thought should mean that it should be extended to everybody. And so, of course, the death penalty continued after that. And there's this correspondence between Jefferson and Monroe, where Monroe has already informed Jefferson that a number of hangings have already taken place as a result of this rebellion. And the question he's asking Jefferson is when it's appropriate to stay the hand of the executioner. And Jefferson responds that that's an important question, thinks that there's been hanging enough at that point. Jefferson is a believer in the maxim that any punishment that goes beyond necessity is tyrannical. But again, in Virginia, in that colonial era, there was a number of people, including Gabriel, who were hanged as a result of the rebellion that took place, where again, Gabriel was just trying to earn his freedom. And then, of course, we have the McCloskey decision, which I think Professor Sy has really summarized really well for everybody, where that study looked at 230 variables. And I think, again, the most telling statistic from that was that people that killed white victims were 4.3 times more likely to receive the death penalty than others. And so we see that the most pronounced aspects of racial discrimination in the race of the victim. There was also some finding lesser in terms of percentage of race of the defendant discrimination in that case, but the focus of the discrimination that was identified by the Baldus study was this discrimination based on the race of the victim. And so again, I want to talk a little bit about the Equal Protection Clause as we think about this area. Of course, that was the focus of the McCloskey decision, which again, Justice Powell has been noted in his retirement, again, too late, but he did say that that was the decision he regretted most. In fact, I think he told his biographer that he regretted really all of his decisions in the death penalty area. And because it was a 5-4 decision, that's a very significant admission to make in a case where that's occurred. If we go back to in terms of thinking about the Eighth Amendment, I want to focus a little bit on the history of the Equal Protection Clause that actually ended up in the Constitution. And a lot of people kind of miss this history a little bit because McCloskey talked about how you basically couldn't use statistics alone to approve a claim of discrimination, that you had to, as Professor Sy said, show discrimination. The language of the court was in his case. So, and again, you're not likely to find a prosecutor who admits openly to prosecuting somebody on the basis of racial discrimination. So you're going to have to find other things. Stephen Bright in Foster versus Chapman actually found some really kind of smoking gun evidence in a case where the prosecutor's notes really showed that there was systematic racial discrimination going on in that case. But these claims are under McCloskey are difficult to bring. And we've seen a number of challenges for like peremptory challenges, and the Batson regime has been used to try to show racial discrimination and jury selection. And we know that there have been a lot of cases where we see all white juries end up, or near all white juries. And part of that has to do with another procedure that the Supreme Court has authorized, which is the death qualification process. And because more minorities tend to be against the death penalty, more minorities tend to get struck from juries. And that's how you end up with these either all white or near all white juries. And really, I view that as a really invidious form of discrimination because for one thing, you're leading to, the studies show you have more conviction prone juries when you have a death qualified jury. And you're already talking about the death penalty before you even start talking about the guilt or innocence phase of a case. But in terms of looking back at the history of the the 14th Amendment, I want to go back to the Civil Rights Act of 1866. That was Congress passed the Civil Rights Act of 1866, and that it was intended after we have the 13th Amendment, which was ratified in 1865. We have this debate about equal access to the courts and also about equal punishments. There were so-called black codes that were enacted where people would get different punishments depending on the race of the defendant and the race of the victim. And there was Frederick Douglass, I think, in a speech he gave in July of 1852, pointed out that in Virginia, there was over 72 crimes that were death eligible if you were black, and there was a very small number of crimes that you would be death eligible for if you were white. And of course, enslaved people were often subjected to completely separate laws as well, going back in history. But in that Civil Rights Act of 1866, it of course talks about, and this is a prelude to what the language of the 14th Amendment, that the language in Section 1 is that all persons in the United States are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as a punishment for a crime whereof the parties shall have been duly convicted, shall have the same right in every state and territory in the United States to full and equal benefit of the laws. And then it goes on to say, and shall be subject to like punishment, pains, and penalties. So the clear intent of the Civil Rights Act of 1866 was to have this equality of treatment regardless of race in the criminal justice system. And as the Baldus study pointed out in McCloskey, we've just never achieved that in terms of the equality of treatment of citizens. There were some questions actually about whether or not the Civil Rights Act of 1866 was constitutional. There was a big debate about that, and that led to the idea that we needed to have the 14th Amendment. And the 14th Amendment was said to constitutionalize the Civil Rights Act of 1866, and actually the Civil Rights Act of 1866 was then recodified in 1870 with the same language that I just mentioned. And so I think it's really telling that the idea of equal treatment, including in punishment, was very much a part of the 14th Amendment. And the other thing I think that has been missed here is, again, the statistics. The court of McCloskey said you can't use statistics alone, and we had attempts to pass the Racial Justice Act in Congress. We did have a couple of states, North Carolina and Kentucky, I believe, that did pass racial justice acts at the state level. But when we think about the death penalty, and we think about the whole idea of equal protection of the laws, something I've been working on a lot recently is thinking about the death penalty as torture. And if you think about going back to the Universal Declaration of Human Rights, and we actually have like the International Covenant on Civil and Political Rights, which the US actually did ratify, those both state that there's an absolute prohibition on torture, and there's an absolute prohibition on cruel, inhuman, or degrading treatment or punishment. And if we look at what's been happening with the death penalty, there was a case recently where an individual in Oklahoma came within 4 hours of being executed. And in terms of thinking about the idea of psychological torture, which is prohibited by the UN Convention Against Torture, which again, the US also ratified, there's a prohibition against both physical torture and psychological torture. And if we're going to actually have universal human rights, and I know this is something Sister Prejean has also talked about for a long time, that the death penalty really is a torturous punishment, that, and if you look at the case law that defines what is psychological torture in a state like Alabama, which has the death penalty, they use that definition of psychological torture, which they define as the awareness of one's impending death and the helplessness to prevent that death. They use that as an aggravating factor in criminal cases to aggravate a case to actually make it into a death penalty case. But ironically, if you were to apply the same definition to people on death row, you would say that you have the psychological torture on steroids, because you have the people being made aware of their impending death, and they are helpless to prevent that death. And the very idea of equal protection seems to me to align very well with the idea of the protection of universal human rights, which I think is something we need to spend more time thinking about and reframing the debate about the death penalty in that respect, because it's very clear that throughout history, the death penalty has been used in a completely racially discriminatory fashion. At first, incredibly overtly, going back to slavery, and the legal codes that actually set out explicitly separate punishments for Blacks and whites. And now we have this more sort of covert form of discrimination, where people bring these, challenge jurors. They say they're not doing it for a racially discriminatory reason, but then when we really find out, we get some discovery on that, we find out that, well, maybe there is actually racial discrimination going on there, as cases like Stephen Bright was able to show. So I think I'll end it there, and look forward to your questions.
Thank you so much, Professor Bessler. I've been jotting down questions based on everything you all have said so far. Last but absolutely not least, I would like to turn it over to Professor Harawa.
Hi, thank you, Alex, and I'm so excited to be in conversation with everyone and to engage in your questions. And thank you so much to the editors of the Washington Lee Journal of Civil Rights and Social Justice for convening this super important symposium. So as Professor Bessler alluded to just a moment ago, obviously a longstanding concern about the administration of the death penalty has been the potential and the actuality of racial discrimination influencing who gets to live and who gets sentenced to death. And so in my remarks, I'd like to focus on the question of who gets to decide to sentence people to death and why they make that decision, taking a moment to ponder a little bit more deeply about the jury. And what I hope this highlights is that it's impossible to administer the death penalty in a way that eliminates the ever-present risk of race influencing the decision of who gets sentenced to the ultimate punishment. So for decades, study after study has shown that race influences capital punishment in a multitude of ways. And so right now, close to 58% of people on death row are people of color, with 42% of people on death row being Black, approximately 13% of people on death row being Latinx. And it's remarkable, as everybody's alluded to thus far, about what people are sentenced to death for and what people have been executed for. And in 75% of cases that have resulted in an execution, 75%, the victim has been white. And when you think about cross-racial killings, since 1977 in the modern death penalty era, 295 Black people have been put to death for murdering a white person, while only 21 white people have been put to death for murdering a Black person. And then when you pile on top of that, the fact that study after study shows that an all-white or mostly white jury is more likely to sentence an African-American or Black defendant to death, and that study after study shows that juries are more likely to return a death sentence when the victim is white, then it becomes really clear, at least to me, that there is no way to administer this punishment in a way that will ever ameliorate the influence of race. And prosecutors know these statistics too. So not only does it affect their charging decisions in terms of who faces capital charges in the first place, who gets bargained down from capital charges, but it affects the way that prosecutors try their cases, including who they want to serve on their capital juries. And so I'd like to briefly highlight the case of Curtis Flowers, because I think it's a stark and recent example of this phenomena. And so Mr. Flowers' plight was chronicled by the popular podcast In the Dark. If you haven't listened, I hope you do, because it's really chilling in so many ways. But a Mississippi prosecutor there, Doug Evans, tried Mr. Flowers 6 times for the same crime. And the crime involved a mass shooting at a small town furniture store in which 3 of the 4 victims were white. And every time the jury was white or mostly white, they condemned Mr. Flowers to death. But the 2 times where the juries were relatively diverse, they resulted in a mistrial. And so in recognition of this, Evans went out of his way to strike as many Black people from Mr. Flowers' juries as he possibly could, striking 41 out of 42 potential Black jurors. And even though the charges against Mr. Flowers were eventually dropped after the Supreme Court reversed his conviction, finding that Evans discriminated in jury selection, he spent 23 years of his life on death row. And again, it wasn't a coincidence that Evans knew that to convict Mr. Flowers, a Black man accused of killing 3 white folks in a small Mississippi town, he needed an all-white or mostly white jury. And so the question is, why is it then that when juries are all white or mostly white, they return a death sentence? But when the jury is diverse, and especially in Mr. Flowers' case, they couldn't reach a verdict. And I think one key reason for the disparities in the imposition of capital punishment is that we haven't really come up with a way to adequately reckon with the widespread conscious and subconscious racial biases that people harbor, which acutely affect all aspects of the criminal punishment process, but it affects the capital sentencing process in very specific ways. And in fact, when you think about how capital sentencing works, in many ways, it invites the jurors to play on their racial biases and prejudices when deciding who gets sentenced to the ultimate punishment. So for instance, the death penalty is supposedly reserved for the worst of the worst offenders. And oftentimes in capital sentencing regimes, juries are required to think about the risk of future dangerousness or violence that a defendant poses when deciding whether to sentence him or her to death. But when studies show that white people, consciously or not, are more likely to perceive Black people as violence prone and are more likely to associate darker skin with danger, violence, and criminality, then there is no reason to believe that this factor could ever be considered or weighed in a way that is not infected with racial bias. And the studies show this too. I mean, so studies show that when faced with Black and white defendants with similar aggregating factors, white juries are more likely to sentence the Black defendant to death while sparing the white defendant's life. Likewise, white juries are more likely to consider a white defendant's mitigating factors while ignoring a Black defendant's same mitigating factors. And while the data is not as well developed for Latinx defendants, it seems that that same trend is holding true there too. And so what I think this shows is it's really reflective of our race perception of humanity and who is worth saving. And that race perception of humanity is inextricably linked or tied up in capital sentencing. And at bottom, white juries or almost all white juries don't see the humanity of Black and brown defendants in the same way they see the humanity and are able to weigh the humanity of similarly situated white defendants. And white juries don't view as serious the murder of Black and brown people as the murder of white people, because they value white people more than they value Black and brown people. And I guess this shouldn't be surprising. So we know that overt racial biases exist throughout the country. I mean, if anything, the past 5 years have only proved this to be true, with hate crimes on the rise and with more people thinking it's socially acceptable to espouse racist views in public spaces. And we know that many, if not everybody, harbors some kind of subconscious or unconscious racial bias. So again, why would we let people decide who gets to live or die with this understanding on all of our minds? And yet, because of this knowledge, and despite this knowledge, we have no way to account for it or to check for it when we're thinking about how to administer capital punishment. That means that on the front end, there's no way to ensure really that racially biased people do not make it onto juries. For instance, we know that voir dire is not really an adequate check against that happening. There's no real way to test whether racial biases affected the jury's view on the back end, other than perhaps conducting time-consuming and expensive jury interviews long after a conviction is final, assuming you can even conduct such interviews because some jurisdictions forbid them, and then assuming that juries are even willing to talk about what they discussed in the jury room, because most people probably aren't comfortable discussing their own racial biases. And so I guess the question that I always come back to is, why is it then, knowing that we know people harbor racial bias, knowing we can't fully detect or measure a person's bias, and knowing that we can't capture all bias that is expressed, let alone unexpressed, that we would let 12 people decide whether someone gets to live or die? And so even in theory, if you believe in capital punishment, which I hope you don't, given that you're at the symposium, why would we allow a system so riddled and so infected with racial bias operate in this way? I mean, it seems to me that we all start from the uncontroversial premise that Chief Justice Roberts articulated in Buck v. Davis, that discrimination on the basis of race is odious in all aspects, especially pernicious in the administration of justice, that we would have to jettison the death penalty altogether. And so I'd like to just take a moment to put a human face on this problem by uplifting a client that I'm currently representing who is on death row in Texas and who has a cert petition pending before the Supreme Court. Andre Thomas is a Black man on death row for murdering his estranged white wife and their biracial children. There's no question that Mr. Thomas is severely mentally ill, and therefore what the jury had to decide in his case, given his severe mental illness, was whether he deserved to be put to death or whether he should spend the rest of his life in prison, whether they would see his severe mental illness as a mitigating factor that would excuse him from, or should excuse him from, the ultimate punishment. And 3 of the jurors who decided to sentence Mr. Thomas to death openly expressed their opposition to interracial marriage in their jury questionnaires, saying things like it was against the will of God for people of different races to marry, that they didn't believe in mixing bloodlines, and that biracial children don't have a race to belong to. And so these jurors who openly express beliefs that are deeply, deeply founded in severe and the most odious type of racial bias were still allowed to sit in judgment of Mr. Thomas and still allowed to sentence him to die. And so if we think about it, right, if these jurors felt comfortable openly expressing these types of racially biased views, imagine the views they didn't express. Or imagine the views that they harbored that they didn't even realize reflected racial bias. And again, I ask myself, how is it that we can allow people who are all flawed get to make this irreversible decision? And so I will leave it there, and I'm looking forward to engaging in questions and conversation.
Thank you so much. Now is the time. Audience, if you want to ask any of our visitors questions, please drop them into the Q&A. And Professor Tsai, as he said, has to depart early. So if you have a question for him, I would go ahead and get that going sooner. As I don't see anything in the Q&A, I am going to wield my moderator privilege. And I think there's some themes really that I've seen across all of your presentations that I'd love to hear from you all on. And one of those is, how can we make procedure meaningful, right? Because short of abolition, right? Because that seems to be the obvious answer. McCloskey spent a lot of time emphasizing sort of, well, we have all these procedures that can make things fair. And look, we have Batson in a way to make sure that prosecutors aren't engaging in discriminatory strikes. But, ultimately, how can we make these kinds of procedures offer anything meaningful, especially when courts frequently tend to undercut the substantive rights attached to these procedures? I'd love to hear any of our panelists weigh in on that one.
I'm happy just to start the ball rolling. One thing we haven't talked about, which has had an impact and will have to get reversed, is so-called habeas reform, because although, as I mentioned in my part of the presentation, there were some successes early, late 80s, early 90s, and Bright and others were able to get hearings in state court, and they were able to get a hearing on their federal habeas petition. At the same time, we have huge movement to curtail habeas and also to basically decide a lot of state and federal habeas petitions on the papers. So what you start to see is the disappearance of hearings, which is happening for a number of reasons. But one of it's happening in part as part of this effort to just give prisoners one bite at the apple. This was the big thing that was the big goal of a lot of reformers on both the Democratic and Republican side of things. So we have a lot of these cases where lawyers are getting involved in giving these cases a fresh look for the first time at this late stage, and will not be able to raise the kinds of issues of discrimination or various procedural flaws, precisely because of what the AEDPA and other kinds of changes have wrought in the last couple of decades. So I would just put that on the table as something that needs attention, besides the many substantive things that we need to pay attention to.
I guess I'd jump in too real quick and say, if you look back at the history of the death penalty, of course, we used to have the mandatory death penalty. The statute said if somebody committed a crime, they shall be executed, which the Supreme Court has said we're not using that anymore. And actually, there's been a lot of litigation in African countries actually about that, moving away from the mandatory death penalty as being something that's not seen as consistent with modern human rights law. Once you have the discretionary death penalty, you leave room for all these kind of unconscious or overt biases that people have that Daniel talked about in his remarks. And I think that one of the things, again, I mentioned this before, was the death qualification process. But because in criminal cases that we've had the consensus that it has to be unanimous sentence. If you just have one person that's against the death penalty, then you don't get the death penalty. And that's why we've seen the number of death sentences actually decline dramatically with the appearance of life sentences. People are less willing to vote for the death penalty, even if they're death qualified. But if you have not a death qualified jury, then you're much more likely to get people on the jury who don't like the death penalty. And so if that reform was made, I think Justice John Paul Stevens once said in beginning one of his opinions that there's millions of Americans who are against the death penalty. The polling's very split. But if you continue to allow people to exclude all the people that are opposed to the death penalty from juries, you'll still end up with a lot of death sentences because you've screened out ahead of time people that would support the death penalty. And I would say the last point would be on the evolving standards of decency standard. The things that they use to judge that is legislation and jury verdicts. And if you're skewing the data, no social scientist would allow you to do that, to get a snapshot of what people's real feelings are about the death penalty. And that I think the Supreme Court should take a look at that and say that's discrimination because it's excluding a lot of people from sitting in judgment in death penalty cases.
Yeah, I guess the other thing I would add is we just need to kind of ensure we have an adequately funded and resourced capital defense bar. I mean, so to the extent we have capital trials in some jurisdictions that last a day and a half, 2 days, 3 days, including jury selection, right? it just can't be that the case is tested as rigorously as it should have been if we are to ever have a capital system, right? So if we are going to have this system, we need to ensure we have defenders in place who have all the resources and time and money at their disposal to unearth all of the issues that may come up in any given case, whether it's racial bias, mental illness, prosecutorial misconduct, whatever the case may be. And quite frankly, we just don't have that in a lot of the places where the death penalty is most frequently sought or administered. And so it's really hard to think about what procedures we need if we don't have the people to wield the procedures in a way that will redound to the benefit of capital defendants.
Yes, I think all of those are excellent points. And the presentations tomorrow will discuss sort of the benefits that Virginia received from having effective capital defense systems and support for attorneys. We do have something in the chat, which I will go ahead and read, and then I'd love to hear from you all on. A question from my colleague here, Professor Todd Peppers. Do you think that today's court is more willing or less willing to consider in capital cases the type of statistical evidence that was unsuccessfully presented in McCloskey? Is this less a problem about capital punishment and more about the justices not understanding social scientific research? Yeah,
It's a great question. It's a great question. Happy to jump in and get the ball rolling. The way I understand McCloskey, after going behind McCloskey, and then certainly as we've thought about the aftermath of McCloskey, is to see that decision as representing something different than what we've seen the Supreme Court or federal judges do in other kinds of cases where they're perfectly willing to entertain fairly sophisticated quantitative evidence. So it can't be the case that there's a generalized hostility to social science evidence or complicated quantitative evidence. I think the proper way to understand McCloskey in a historical context, and this helps to explain why I don't think the court is any more interested in looking at that kind of evidence now and may never in my lifetime, is that it's all about the fear of the consequences. It's a consequential impact of embracing the statistical evidence in a structural racism kind of challenge, right? That's really what freaks out Powell. He's got no beef. Nobody has any beef with the soundness of that evidence, but it's with the ability to attack the existing criminal justice system, any part of it, with this kind of evidence that they would otherwise accept perhaps in other contexts. How do they distinguish it from any other context? Well, I mean, they sort of try to say like, well, there's a few more players involved. There's more discretionary actors, right? This is the part of the decision where he says, well, there's juries and there's judges, and all of this is true, but that doesn't necessarily mean we can't isolate, right? Discretion being used in inequitable and consistently inequitable ways, such as that of the prosecutor, which many of us think that the Baldus city at a minimum did. So I think it's less about a general lack of understanding of evidence, and rather a kind of general commitment to insulate the criminal justice system with all of its inequities as much as possible, which is a very dispiriting kind of thing. Means that a lot of work has to be done in a kind of incremental way to create as many tensions in doctrine and in within the system itself as possible, until you have a different political moment, perhaps.
Yeah, I guess I'll if we're going in order here, I'll jump in. I do think the Supreme Court obviously have to change their opinion, in terms of whether or not they were going to allow access to that kind of statistical data to be used in these cases. I would say that statistical data is used all the time in other kinds of cases and in discrimination cases. And so why you wouldn't look at statistical data in the death penalty context is really beyond me to understand why they wouldn't allow that. I do think there's a little bit going on here in terms of the justices have long kind of put the death penalty in a kind of a separate box and they just have a different kind of view of the death penalty. And they, again, when I was talking about before about the idea of torture, in the past, going back way back the Enlightenment, people abolished torture, but they kept the death penalty often. And so they just viewed the death penalty as something other than torture. But at bottom, what the death penalty really is just a series of credible death threats that are being made, which ordinarily are unlawful in our system of justice. So we have laws against use of people making death threats against people, but these are state sanctioned death threats, and they're very credible because they're backed by state power. And so I do think that, and if you look at like non-lethal corporal punishments that have already been declared to be violations of the Eighth Amendment, Justice Blackmun, when he wrote a decision as an Eighth Circuit judge in dealing with Arkansas prisoners, said that whipping prisoners was a violation of the Eighth Amendment. We have other cases where the court has described it as an obvious Eighth Amendment violation to handcuff somebody to a hitching post, essentially for 7 hours, and they get dehydrated. But then the death penalty comes along, and the court just seems to look the other way on that. And it's really inexplicable as to why they would basically, there's a consensus that non-lethal corporal punishments are unconstitutional, but yet they continue to allow this kind of lethal form of punishment. So we need to start thinking about the death penalty within the realm of torture and obviously extreme cruelty in terms of the way it's administered.
Yeah, I guess the only thing I would add is that it strikes me as being highly unlikely that the court isn't aware of the statistics and how they play out and what they mean. I mean, Justice Breyer has been shouting about this for a really long time, and I think his voice will be missed in this regard once he retires from the court. And I try not to be super pessimistic, although I guess maybe that's my nature. But I mean, the court showed a kind of bloodlust in the waning few months of the Trump administration, where they let the federal government go on a killing spree. And just not only turned a blind eye, but let it happen, condoned it. And so, I think it's a court that a majority of the justices on the court are in favor of capital punishment. I think they think capital litigation is inefficient and unfair to victims. And I don't think they care about procedure as much as perhaps they should. So it would strike me as being hard to believe that it's just out of ignorance, not understanding the consequences of capital punishment and all the ways it's riddled with racism. It's just that they're willing to live with it or to let people die with it.
Yeah. Yes, right. I fully agree with those points about the court's kind of bloodlust and certainly indifference, right, to issues of pain and suffering. And your point, we don't have any more questions in the Q&A, so I'm wielding this moderator's privilege intensely, and I'm having a great time doing it. So, your points about the history, right? Because our understanding of the role that race has played in capital punishment, that race has played in lynchings, and executions, and not just of Black people, right, but of other minorities, other groups. How can we weaponize that history, right? Before he had to leave, Professor Tsai mentioned, right, that attorneys sort of turned McCloskey into a sword, and litigated these sorts of issues in cases. I mean, none of this is new, right? It's all known. Scalia, circulated that sort of infamous memo in McCloskey versus Kemp, where he said it's not about a failure of proof. I already know all of that race infects the criminal legal system. So what can we do with those pieces of information? How can we weaponize history?
So I think one thing that you're starting to see more, which I think is a really positive kind of development in capital litigation, is folks starting to use kind of narratives about generational trauma and legacies, in particular jurisdictions, as part of an overall mitigation strategy. And so I do think we're starting to see more of folks kind of linking current practices in terms of the administration of capital punishment to kind of past kind of racist terrorist moments. And the more you can do that with specificity of like linking within jurisdiction, like this is the direct descendant of this. And this is what you have to reckon with, court, as you kind of say that what happened here is okay. I mean, I hope if nothing else, it makes folks think twice and feel uncomfortable about what's happening. But I do think it's a really positive development. I think EJI has been great at this. It's kind of just thinking about how to kind of use past as part of a current client's story, because clients don't grow up or exist in a vacuum. They're part of a community, and that community has a legacy. And so I think it's happening, and I think it's enlightening. And I think we have let courts not be confronted with the past as much as we should. And I think it's happening more and more. And I hope that is only a positive development.
Yeah, I'd echo that same thing, and I think Equal Justice Initiative have done a great job of they've this kind of like lynching memorials that they are putting out there to let people know what happened, and it's sort of public information campaign. I know in Minnesota, there is in Duluth. I wrote a book about the history of lynchings and executions in Minnesota, which was mentioned in the introduction. But there was a lynching there of 3 African-American men in 1920. That occurred from a traveling circus that coming through town. And it was a false accusation of rape in that situation by a white woman that led to the lynching. The men were actually pulled out of the jail and lynched from a lamppost in Duluth. And there's now a lynching memorial there on the streets of Duluth to remind people of that. After that lynching, there was actually a Black man named Max Mason who was actually convicted of the rape in spite of the lack of any kind of physical evidence. That individual, Max Mason, was later, his sentence was, he was released from prison early on the condition that he not return to the state. I'm sure he didn't have any intention to do that after what had happened there in 1920 in the justice system there. But there was a petition, and it was the first posthumous pardon was issued to Max Mason, actually, in the wake of the George Floyd killing in Minneapolis. And Jerry Blackwell, who was one of the lawyers that prosecuted Derek Chauvin in that case, was the lawyer who put forward that petition. And I think, again, that draws attention to the fact that the justice system has made decisions in the past which were clearly wrong, and drawing attention to the judicial system's own flaws, I think is helpful as we think about going forward with challenges to death penalty, because people are seeing more and more with the exonerations that the system does clearly make many mistakes. And again, I was actually listening to Rob Dunham. He was giving a guest lecture at my death penalty seminar I teach at Georgetown, and he was talking about how these are not just accidents in a lot of these cases. These are intentional prosecutorial misconduct in many cases that are happening. So these are not by accident; they're by design. People are seeking death sentences intentionally and maybe not turning over exculpatory evidence as they should, which leads to wrongful convictions, and we know that's a fact.
Thank you. So we have a question, another question coming in our last little bit of the panel. How can new lawyers continue to force judges and justices to see statistics on racial bias, both conscious and unconscious, mental health or economic status as clear favors in abolition, and factors that demonstrate the death penalty can never be implemented in a fair and unjust manner?
Kind of playing off what John just said, I mean, I think it's important for us to be honest, not just in death penalty litigation, but in all litigation, about the biases and prejudices that influence the way our criminal punishment process works, right? And I think one of the things that makes me most hopeful is that I feel like our students are starting to kind of be more forceful about reckoning with the ways in which our system has been operating and is operating in incredibly unfair and biased ways. And, I know when I was trained as a public defender, we didn't raise race unless it was like directly relevant to a particular claim. And even then we were kind of gentle about how we did it. And I think that's changing. And I think the more we do it, and it can't just wait until capital punishment, I think it has to happen all the time, the harder it is for people to look away. And if people still look away, the public information campaign is still important, right? Because it's like as John said, if we don't talk about it, then there's no real impetus to change it. And so I think it's just having those hard conversations, acknowledging that there is a lot of work to be done, and that part of that work just needs to be honest conversations and reckoning with past and present disparities and injustices.
Yeah, and I'd agree with that. I mean, fully. I mean, I think one of the things that lawyers as advocates have a responsibility to do is to raise the troubling statistics, right? Even if the courts have not shown a receptivity to entering those into evidence, those can still be argued, right? You can still bring motions, you can still, and they may actually influence the decision maker in more subtle ways, who become aware of that. And you're educating the judge as well as the public with respect to each time you raise the use of statistical information. So even if the judge ultimately excludes it, it could impact the outcome of the case, because the judge may be more sensitive then to that issue as you look at it. So you never know who the audience is going to be, but I'd say, you know, it would be foolish not to raise the issue if you have statistics that show that there's some sort of racial bias or some sort of racial prejudice in whatever context is you're looking at, because I think it's important to raise it, even if it's only for history. We need to raise the issue so that it's there, it's documented, and so that it can be looked at. And as Justice Ginsburg, you know, famously talked about, you know, sometimes the dissents turn into the law, and so we have to be looking to that as well in terms of thinking about how the law might develop in the future. Even if the current Supreme Court doesn't seem receptive to some of these arguments, a future court may well.
Thank you both. I think those are good points to make, right, in terms of just making the argument always. And I certainly agree that our students seem to be increasingly, consistently like ready to bring those topics up. My own students certainly are, really, from our first day in class, which has just been lovely. Some of them are watching now, I suspect. So, you know, we're just about out of time, but any other final thoughts, things that have occurred to you? You know, things, what can we do other things we can do going forward?
Well, I guess I'll jump in quickly. I mean, I think one of the things I've been thinking about a lot recently is kind of the rule of law. We've had a lot of, you know, an attack and assault on the rule of law recently, and including with respect to death penalty cases and the procedures where the Supreme Court sometimes has actually been directing lower courts not to intervene in cases, basically, you know, overturning stays that were issued by lower courts. And so I think we need to be thinking about how to, especially when you're, you know, in law school and you're training yourself to be the next generation of advocates, to really uphold the rule of law in the sense that you're protecting human rights as part of that exercise. And when we talk about equality of treatment, right, we're talking about equality treatment for all. And there's some things that are nobody should be subjected to things like cruelty or torture. And so it's the job of the lawyer to raise those claims and to make sure that the protections that are set forth in our Constitution and in places like international law actually are given effect. Because if you're allowed to torture people that are on death row with death threats, you don't really have universal human rights. You have almost universal human rights, maybe, but you don't have universal human rights. And so I think we need to be thinking about how we can push forward the idea of universal human rights going forward.
Yeah, and I will guess I'll just end with something that also makes me hopeful. Is I think as citizens, not just as lawyers, we need to demand judges who will be thoughtful and who will think about this and who have life experiences that reflect all different kinds of backgrounds and sympathies and and professional backgrounds. And so, I mean, I think the fact that we have more and more public defenders on the bench will ultimately make a difference to how people receive statistical evidence and how much that will weigh on them as they are making the kind of over and subtle decisions in the numerous ways that they have to when kind of resolving cases, right? And I think we should demand that of our elected officials, that we want benches that care deeply about the most marginalized folks in society, and those who are prosecuted in capital cases and who will ultimately sentenced to die are oftentimes the most marginalized folks in our community. So having folks in powerful positions who care and who are thoughtful about all the ways in which power and the lack of power influences people's lives can only make our system a little more fair.
Right, we are just about out of time. I'd like to thank Professor Bessler and Professor Harawa for joining us. Kind of virtual applause since we're not in the symposium room. Thank you both so much.
Thank you.
Thanks, everyone.
I just wanted to echo Professor Klein and thanking you all for joining us. And thank you, Professor Klein, for moderating that panel. We're about to go on a 15-minute break, but before we do, I just wanted to bring your attention to a PowerPoint that we're going to be playing. This PowerPoint reflects the faces of all those executed by the Commonwealth of Virginia. Professor Peppers was gracious enough to put this together for us, and now we're going to start playing that for you. See you all back here at 3. Thank you.